Hello and welcome. My name is Jennifer Gates, Field Services Director for the California Preservation Foundation. Thank you for joining this webinar entitled Section 106 Webinar Series, Module 4, Section 106 and Public Participation. The format for today's webinar will include a presentation followed by additional time for questions and answers. There is a toolbar on the right side of your screen. If you have a question at any time during the presentation, please type it in the box and Brian will answer or hold it to the end to answer. You will be muted throughout the presentation. To hide or unhide this toolbar, click on the orange arrow. Today's presentation will be by Brian Turner and Brian Durkin. Brian Turner is a graduate of Vermont Law School and a member of the California Bar working in the San Francisco field office of the National Trust for Historic Preservation, a national nonprofit membership organization based in Washington, D.C. Mr. Turner represents the National Trust as an advocate, enacting its mission to save historic places around the United States. His work focuses on administrative and legal advocacy and involves frequent engagement with federal agencies throughout the West, pursuant to the consultation process of the National Historic Preservation Act. Brian Durkin is a summer legal intern for the National Trust for Historic Preservation in the Washington, D.C. office. In the fall, he will start his third year at Vermont Law School, where he focuses on environmental law and historic preservation law. Brian has worked for a variety of players in the Section 106 process, including a Northwest Indian tribe, a museum, and a cultural resource management firm. Brian received a Bachelor's of Arts in Anthropology from the University of Washington and a Master's of Science in Archaeology from the University of Utah. Thank you for joining us today, Brian.
Thanks, Jennifer. Brian Turner reporting here. So I want to guide you through a how-to on influencing federal decision-making in the Section 106 process. I understand most of you have had a few webinars previous to this where you understand some of the basics of Section 106. So this presentation will really focus on the public participation requirement and, offer sort of a how-to. Brian Durkin and I have the advantage of having both the same name, so it shouldn't be too complicated to ask us questions. But please feel free to write your question in the box. I'll do my best to answer it and stay on track. But we'll certainly reserve some time at the end of the presentation to follow up on items of interest. So today, our goals are to do four things. First, I want to really establish the legal foundations of public participation in NHPA. The National Trust, we were chartered by Congress originally in 1949, and one of our principal charters that's actually written into law is to facilitate public participation in preservation of historic places in the country. So when NHPA was passed, public participation was a big part of that, and it offers a really unique model that we're going to explore today. Second, I'll provide a few real-world examples of different consultations we've been involved in, I've been involved in specifically on behalf of the National Trust. Most will explain what can go terribly wrong when the process is followed incorrectly, but I'll at least highlight one project where things went well and had a good result at the end of the day. Three, I want you all to take from this presentation certain very specific steps that you can do to engage formally as a consulting party in the process. Finally, the last 15 minutes or so, Brian Durkin will summarize some of the really interesting case law on public participation and highlight some of the key take-homes from those cases. So, National Historic Preservation Act of 1966, written and codified into law at 16 USC 470. One of my favorite quotes from the law is that the historical and cultural foundations of the nation should be preserved as a living part of our community life and development in order to give a sense of orientation to the American people. And, I really like this as a foundational statement because we're not just talking about preserving things for antiquity or just for the past, but really so the present generation can understand. It's really for the public benefit. And so Section 106, as you all know, it's a very short passage with certain key requirements that are explained through regulation, but really as a backdrop have at the heart of them, the public interest at stake and holding federal agencies accountable when certain actions through which they have some oversight or some approval process for are going to affect historic resources. And fundamentally, it works to discourage action that would have adverse effects on those properties. And I think what we'll see is that the process is far less onerous for agencies who are working with applicants to do strong project planning at the outset, engaging the public, and work as hard as possible to avoid those effects rather than go through the process of having to try to resolve those effects in an MOA or programmatic agreement. So I just want to highlight some of the key terms in Section 106. Of course, the final decision must be, the resolution of effects must occur prior to the approval or expenditure of federal funds or license. The agency just simply must take into account the effects. That's explained much more clearly in the regulations. And objects protected are those that are eligible for inclusion in the National Register, not just listed, of course. So the three key steps of Section 106, as set out in the Advice Council on Historic Preservation's implementing regulations, are to identify, assess, and resolve effects to historic properties. Of course, if in the identification phase the agency finds that there is no historic property affected, they don't need to resolve them. There's simply no effect in the process. It's over on concurrence with the SHPO. I want to emphasize, and I'm going to discuss consultation and what that means next, but that fundamental to this is that consultation with the public, whether it's a party by right or a party by invitation, and we'll get into who is who, but that consultation must occur at each step in this process. The identification of resources, it's essential that, if a consulting party engaged there at the earliest stage in the process and further assess and resolve. Now, it's possible a consulting party may jump in anywhere in between here, and so they may, by necessity, sort of forfeit their right to be involved in the identification process if they're jumping in the resolution stage. At its heart, all of those questions are the real referee in the process is the advisory council. If that ever becomes in conflict as to what right a consulting party should have. As I mentioned a little bit, earlier, a lot of people speak of NHPA and Section 106 as purely a procedural law. Well, if the agency follows, all of the steps in the process, it's legal and it should go forward. But I think it's really important to emphasize that the crafters and the intent of Congress in passing NHPA, it wasn't just to have the agency go through the motion. It's actually to really give good faith attention to, first, avoiding effects, second, minimizing those effects, and if neither of those can happen, then engaging in mitigation. And that it's key that they follow those specific steps, that you can't just skip the mitigation first. You need to really exhaust and explain why the effect is necessary or in some sort of public interest and cannot be avoided. And the consequence is that, there's major procedural delays that can happen if the agency really isn't, engaged very early. So here's a picture of the regulations. I tried to make it as exciting as possible by making it yellow. But really, we are dealing with very there's about, I'd say that the whole regulatory part of NHPA here, it's about 10 pages of this really finite text. It's very challenging to read, even as a trained attorney. It's constantly a challenge. But this is where it is, and this really sets out the process. The consultation requirement is really the heart of NHPA, and that's been repeated by Advisory Council on multiple occasions. Here's how it's defined in the regulations. The process of seeking, discussing, and considering the views of other participants, and where feasible, seeking agreement with them regarding matters arising in the Section 106 process. I think the ultimate goal here is that we're improving the quality, legitimacy, and capacity of decision-making. It's really outcome-focused. The idea with NHPA is that if you involve the public, you're going to increase the trust of public and arrive at a better result than if the agency was to purely do this without input from the public. And just as a background on public participation, there's a lot of ways that any stakeholder group can be involved. There's a lot of different types of public participation. You can vote, you can express an opinion in a general letter to an agency official, form an interest group, you can hold a demonstration, you can chain yourself to a bulldozer, you can create documentaries, sing songs, but the consultation as codified and as implemented in NHPA is really a very specific legal process, and it's important to emphasize that NHPA confers a right on certain people to participate, and it's a specific legal process that I guess would supplement these traditional forms of participation by permitting direct involvement of stakeholders in executive functions. I would also note here that consultation practice differs among agencies. There's no question about that. A lot of agencies have individual regulations related to public participation in their legal process generally. Some agencies have regulations specifically dedicated to NHPA. But what we've found is that certain agencies with more public participation requirements, generally, say, the Forest Service, are going to differ a lot from, say, the Federal Communications Commission in terms of their practice and engagement with the public, simply because the Forest Service, for example, has more involvement with the public generally in other processes. That doesn't mean that the FCC has any less of a responsibility to the public. And ultimately, at the end of the day, there's a legal remedy that groups can pursue, and that's what helps keep the agencies honest. Now, I think it's important to discuss how NHPA is unique from other preservation laws, and this is by no means an exhaustion of all the different laws that might apply to historic properties, but the one most people are familiar with are NHPA on a federal level, the National Environmental Policy Act, and CEQA in California, the California Environmental Quality Act. Now, I like to talk about this a lot because NHPA really differs from NHPA, I think, in a fundamental way, in that those laws permit the public to issue written comments at certain stages in a procedure after the agency releases a written document. So the documents in NHPA are noticed in the Federal Register. An agency will send out a notice of intent. The public can comment at that point. That's prior to scoping. They can comment during the scoping of the project on the EIS or EIR, in the case of CEQA, the final EIR. And fundamentally there, the agency is required to issue responses. It's required to respond to public comments and concerns. But with NHPA, consultation is very different. It's not appropriate, the courts have said, and as we'll see a little later, just for the agency to write a written decision dispensing of the comments. That consultation with the public is a broader dialogue that must occur, and it really narrows down the parties involved to address issues that are more specific to historic preservation. I just want to also note the sunshine laws. These are fundamental public interest laws that allow the public to attend agency meetings. But again, speaking up at a meeting, having your voice heard, is different than consultation, which really requires that the agency sit down and consider those comments in a more of a dialogue. NAGPRA is the Native American Graves Repatriation Act. This is specific to tribes, but another topic that I'll talk about later does involve consultation with tribes about resolving competing claims to Native American remains. So I mentioned earlier there's parties to NHPA consultation by right, and obviously the agency undertaking the action. Typically that will mean the agency, the field staff in individual regional offices. But there's also a federal preservation officer that each agency has, and if you go to the achp.gov website, you can find a list of all federal FPOs as they're known, and you can give them a call, find out what's going on with the project if you're concerned. The Advisory Council, they are the federal agency. There's a presidentially appointed head. Current chairman of the Advisory Council happens to be the California SHPO, Wayne Donaldson. And they get involved. They have the right to be involved. The agency must notify them of undertakings, but generally will only get involved in a handful of cases around the country that there's specific rules in the regulations that specify when the ACHP will get involved. The SHPO, basically, I call them the delegated. This is our principle of federalism. We've delegated to states the right to determine, what is important and how is the best way to resolve effects to the officer who's appointed by each state governor. Indian tribes and Native Hawaiian organizations have very special rules and that pertain and are often invited by right when a project will affect a property of religious or cultural significance, and that's both on and off reservation lands. Representatives of local governments can be involved, and applicants for federal assistance. Now, local governments and applicants, now that's not by right, but by invitation. And technically, the language of NHPA isn't that you just become a consulting party by your own virtue. You actually request and must be invited to be a consulting party. So it's very rare, and we're going to talk about how you get invited, but I have to say that it's very rare to be denied consulting party status. It's only happened once in my experience at the Trust, and that was when the National Science Foundation denied the right of a Native Hawaiian group to be involved in a telescope project. They got reprimanded pretty hard by the ACHP for that. So generally, if you can prove a demonstrated interest, you're going to be a party to the table. Brian will talk about a little later those specific requirements, but the regulations specify that you can have an economic interest, a legal interest, or just a general concern. It's really pretty loose. Now, I talked earlier about parties by right. Technically, those are signatory parties. They're invited to be a signature to a document that the final Section 106 agreement. Consulting parties, as opposed to the general public, as I mentioned, are invited. They have a seat at the table. They're involved in the process, as I mentioned before, at every stage. They, and I'll go through what it takes to be a consulting party, but you're entitled to receive notices of what's going on, varying meetings. You can provide comments. I will always encourage that your comments be written. You can object to agency determinations of significance. I'll talk about how in the current post office case that's become a big issue as to whether there's an adverse effect caused by the closure of a post office. And then, the important thing here with a consulting party is that in the final agreement, final Section 106 agreement, if you generally, if you decide to become a concurring party, which means you've signed the agreement and now you're a concurring party as opposed to a signatory, you can have future rights where the MOA will specify that, in phase 2 of the project, we'll notify the concurring parties and ask for their comments in 30 days. Programmatic agreements, very similar and more commonly, future rights conferred. There's kind of an ongoing debate with the Advisory Council about whether or not a party that's consulting but refuses to sign an MOA must be granted the rights in the MOA. The Advisory Council's position currently is that they're not, that you can create a legal document and require a signature in order to be involved in the future. The general public, I shouldn't discount that even if you're not a consulting party, there still is a legal role for the general public. You can provide viewpoints similar to, this would be similar to NHPA. And this, I guess, is the stratification that NHPA and CEQA don't provide. There's no, once you're in the general public category, you're kind of just out there, and the agency responds to everybody equally. So how to become a consulting party? Really, fundamental to this is putting your request in writing. That's largely because at the end of the day, if, let's say, hypothetically, this goes to litigation because people can't agree, the administrative record, the record that's before the agency at the time they make the decision is going to be what the judge sees. You can't say, hey, but I called the agency, I asked them on the phone, and if you don't have a record of it, there's no evidence, before the agency that you actually did make that request. So here's my suggestion. I send out this template to local groups across the country, fairly frequently, people saying, how do we get involved? Because it's really, I think this differentiation between a general public and a consulting party and understanding the legal rights is really not something a lot of the public understands. And, frankly, it's not necessarily in the interest of the agency to make it very clear that, hey, guess what? You have a special legal right you can get in our legal process. So this is where the role of the National Trust as kind of an independent nonprofit advocate comes in, that we want to make sure the public knows that they have this right. And so to comply with, I guess, intent of the regulations here, it's important, I think, to specify the passages in the regulations that, indicate why, the public should be a part of the process. And fundamentally, here in the third bullet, you'll see you need a demonstrated interest in the undertaking. Again, that can be legal, financial, just why you're concerned with the historic property at issue. I'd also recommended, to state your interest in being included on distribution lists, and make sure to CC the letter to the ACHP representative for that federal agency, and a list of ACHP staff contacts can be found on their website, www.achp.gov. CC your SHPO. If you know the individual staff member who's responsible for that specific undertaking, that's great. If not, just copy Wayne. And copy us at the National Trust, copy me, that's fine. Local government, whoever, you know, a letter like this is really a political statement. It puts people on notice, and it's fundamental to the process in terms of setting forth, you know, the expectations that the agency might have as to what your points of contention are, and how, you know, ideally will be a guidepost to the consultation to determine, you know, what the public wants to see. I'm going to talk about just a couple cases briefly that I was involved in and what sort of went wrong. Guam was a really unique example. The Department of Defense had a plan, a pretty major development on the small island of Guam, which is about 30 miles long by 5 miles wide, and a big Marine troop buildup, taking a number of Marines from Okinawa, moving them to the small island. And what really got hairy, initially, is that the government, the Department of Defense, was working very closely with government representatives, the Senate, the unilateral legislature in Guam, and they would have secret meetings, and they kind of explored various sites for their projects. And the one that ultimately became of issue in what was a much broader, bigger military buildup was the siting of the firing ranges, a whole complex of firing ranges. And I know this image is a little hard to see, but basically when the EIS came out, the draft EIS for NHPA, it said, this is where we're putting the ranges. It didn't really evaluate other places on the island. It suggested that, in consultation with government officials, we've decided to put it here. So the first real issue there is that the NHPA process was determining the outcome of where the ranges would be located. So then, the question really is, well, what role does the public have here to determine, to avoid adverse effects to properties? Because as we found out, and the reason the National Trust was called, is because the ranges would go right over a really significant ancient village site where the native people of Guam believed that their ancestors still dwelled. There were a number of archaeological sites in the area, and the Department of Defense just assumed, well, we'll fence off the area, and so that'll be good for archaeology, But the people, the Chamorro people were saying that these places are important for far more than archaeology. This is important for understanding, teaching our children about our culture. It's one of the last publicly accessible ancient village sites on Guam. And so we got involved in a pretty serious way. The consulting, we recommended to a number of groups on Guam that they become involved as consulting parties. The government was attempting to execute a programmatic agreement. The advisory council got involved. They were not able to resolve the effects, particularly because of this property, and refused to negotiate on, consideration of other sites by, for instance, doing supplemental NHPA documentation. Ultimately, this resulted in a lawsuit, and late last year, the Department of Defense did agree to do a supplemental NHPA document where they're currently analyzing a number of different sites for the ranges. A situation more specific to California here that I know CF has been very involved in, the LA Conservancy has been quite involved. This is the post office closure. And there are a number of post offices that are threatened. The historic buildings in La Jolla, Santa Monica, Santa Barbara, Palo Alto, Berkeley, Ukiah have all been issues. Venice offers probably the most unique example at this time because of kind of a stall in negotiations. And the National Trust just listed post office closures around the country as one of the 11 most endangered properties. So we have a team that's working on this, engaging in specific consultations. Probably the biggest overall grievance right now with the Section 106 process is the fact that the Postal Service has no comprehensive or programmatic way that they're dealing with closures of historic buildings. They're doing them individually on an ad hoc basis. Nobody knows what causes the decision to sell off a historic building. You know, it may have to deal with the lack of business at that location, but it may have a lot more to deal with getting the revenue, getting as much revenue as possible to close the budget gap with the Postal Service. Ideally, preservation advocates, don't want to see these places go out of public uses, but if they do have to go out of public use, we want to ensure that there are protections placed on the property, ideally that they have some public access component, and we want to get involved in these negotiations. Now, what's happening now, and the second bullet here, is that with a variety of these closures, the Postal Service is telling the SHPO, telling the consulting parties, and telling the Advisory Council, all contrary to the views of those entities, that the closure is really going to have no adverse effect, and it's been proposing a number of ways that it's going to avoid adverse effects, and it's been, attempting, to on an individual basis for each of the post office impose preservation covenants of varying degrees of success. One of the big issues now is whether, the fact that the SHPO can't accept the covenants by law in California. In Venice right now, the city of LA has agreed to accept the covenant, but the advocates and consulting parties want to see that covenant with the strongest possible protections. A letter was sent just yesterday. This is very timely. A letter was sent just yesterday from 15 different local organizations. I don't know that all of them have formally requested consulting party status, but I would advise them to. And they want a really close review of the closure procedure. These are assets that are profoundly important to these communities. This is not just preservation organizations, and it's instances like this, I think, that really reveal the power of NHPA and 106. If there's no NHPA process that's happening, this is really the only way for those entities, those stakeholder groups, those local government, those concerned council members to get involved, to have a dialogue with a federal agency, which in this case, we would say is playing hardball. They're really, a lot of these decisions are seemingly very secretive, and we want more increased exposure to the public. We want better results. Obviously, everybody wants the solvency of the post office. We know that that's a big issue, but our position would be that public dialogue doesn't hinder that. So call me if you want to get involved in your local post office issue. Now I want to discuss tribal consultation, because we've seen this come up quite a bit recently. If you go to the Advisory Council's website, you'll see a number of guidance documents, and that's not a coincidence. I think that probably if you look around at where the law is on consultation, the most fodder you'll find is in the tribal right, because we're really, NHPA is a way of really tying in a broader federal trust responsibility to engage in government-to-government decision-making with tribes, and to make sure that those voices are respected and heard. Government-to-government is a term that dates back as long as we've been a country, but it's been codified very clearly in recent executive orders, and in the latest ACHP revisions to the regulations is made clear. The reason that Native Hawaiian organizations are specified is because they're not tribes as defined in the regulations, nor are non-federally recognized tribes. The 106 regulations make clear that those non-federally recognized tribes, though, have a voice to be consulting parties. Fundamentally, if the court is looking at this, they'll find that consultation is governed by good faith at every stage in the process. Meaningful consideration of tribal views is essential and an often cited concept. What is meaningful? Well, these 3 points might help address that. It means engaging the tribes as early as possible in the process, to be sensitive and respectful of confidential information that's provided. Many tribes don't want, for good reason, information about important religious properties in the public domain. I think that, the other thing that I'll talk about more in a second with the renewable energy projects is that ancestral lands or ceded lands that are not on the reservations can contain really important resources, and the regulations recognize the tribe's right to engage in a process even if it's on a land that's publicly owned. This case was a real landmark. It was the injunction against the solar energy facility, a 6,500-acre project site, 459 natural resources identified in the area of potential effect. And this really came as a surprise to the Bureau of Land Management, which was entertaining the project, because it really felt like, it had made a bunch of contacts with the tribes. It had great records of all those contacts. Of course, the tribes, were really upset with the chosen location for the project, which was on a dry lake bed that contained, significant historic sites. They wanted the project to be moved, but the problem was, once the applicant goes in, it's very, very challenging for the BLM to push them to a different site. So they went ahead, they approved the project. The Quechan tribe sued, and the judge rebuked the agency, finding that, I love this expression, that consultation is not an empty formality. It's not just a process, but it has to be more than a general request for a tribe to gather information about sites and disclose it at public meetings. There needs to be more than that. And I think the last bullet here is particularly important for contextualizing how tribes have a very unique seat at the table, even in comparison to other consulting parties, and that, all of the federal requirements, they could have been made less stringent, but really what legislators have put on the books are very strong laws, and they have not diluted them. And so there, of course, always are proposals. We're dealing with a number of them, proposed exemptions for particular projects in Congress. Very few go through, but it always is something that concerned legislators will put in their back seat, and that the National Trust consistently opposes those any proposed exemptions to Section 106. Finally, and then I'll let Brian discuss a few cases. I just wanted to bring up a success story, what I thought was a success story, where consultation really had an effect of making a project just a lot better. Nike Site Summit is a property listed on the National Register above Anchorage. Really unique, fantastic place where one can really get a sense of what the Cold War was like in Alaska. It was manned 24/7 for something like 40 years. And the Army just wanted to get rid of it. It was falling apart. It was a public nuisance. They wanted to demolish about half of it. The SHPO of Alaska called us, and we got involved. The Cold War Museum was involved, their Friends group, the Alaska statewide, and the Park Service. The Park Service actually wrote a report, which is authorized by Section 106, and an important one to put in your toolkit in the event an NHL is threatened, but also in this case an informal, what they call 213 report was written, and it showed that demolition of these would cost more than retention, and it proposed specific methods based on the Park Service expertise on how to facilitate the rehabilitation. The Friends group, they wanted these things saved so much. Several, members of the Friends group were veterans who had worked there. That the MOA that was ultimately signed gave them the ability to go and do work parties there, and they ended up preserving 9 of the 12 that were proposed for demolition. So the mitigation, and just to point to that, a retention plan for the building, the ability of the Friends group to rehabilitate, public access to the site, and a HALS report. I'm going to, okay, Jennifer's telling me to go. I'm just going to summarize a couple. When we talked about some of these points already, how do you find out about what's going on? Generally, people find out too late. I would admit the amount of calls that we get sort of after everything's been decided are just really, it's really too bad, because ideally a federal agency should, have some motivation to involve parties early. But the SHPO has great resources. I think the California SHPO, their newsletter is fantastic. They've always been very helpful to us, and with tend to have good relationships. The Federal Register, you're not going to find every undertaking noticed in the Federal Register, but it tends, since NHPA also requires an assessment of effects when a project will have a major effect on a resource, it requires an analysis of impacts to scenic resources and aesthetics, as well as historic properties. You can, and Brian Durkin came up with this, I did not know this, you can limit your result search by zip code, so you can really find out what's going on in your community, what's been noticed. The ACHP has a great case digest where they talk about varying projects that are going on all throughout the country. It's generally written very well, sort of short bios of what's happening. Engaging federal preservation officers has been really useful. They tend to be very preservation sympathetic. That's why they're hired. They don't always have the greatest ability to sway their staff in the field. Most are located in D.C., but certainly they can help point you in the right direction. Local and statewide, CPF here, of course. And then, of course, you can contact the National Trust for Historic Preservation. This, I'm going to skip through this. We really talked of this before, but, you really can participate at any stage in the process. It's very rare that an agency will deny your request, as long as you make a good faith effort to explain your interest. I think it can be much more challenging for individuals to request consulting party status. It's far better and easier to, if you're a nonprofit, to demonstrate, cite your mission, cite some of the projects you've been involved in, why you have expertise. there is an important point here about the nature of consultation I forgot to mention, but it's generally judged by the size and nature of the projects. The federal agency is going to have a lot more of a requirement to engage the public the bigger the project. So high-speed rail certainly is that large of a project where I think that there's a strong case to argue that more could be done to involve parties that would be affected by that and notify them. Termination, I guess I should mention that it happens very infrequently, but a couple cases a year, the agency will go to, they will request final comments from the advisory council. The council may convene a panel. This happened with Hangar 1 a number of years ago in Mountain View, and there was a big public hearing where the advisory council seeks the views of the public, and that's not just consulting parties, that's everybody. The agency generally, if they're seeking termination, intends to go along despite what the advisory council says, but I have to say I think the public process is very relevant because it can mitigate some of those impacts. So in the case of Hangar 1, rather than tear down the entire structure, they engaged in a process of taking off the panels. So hopefully we'll see a good outcome when if they decide to put the panels back on. In the comment about program alternatives, I don't know how much you all talked in earlier webinars about PAs, but I think there's a general concern out there, certainly among the National Trust, that an agency will do a PA, they'll execute a programmatic agreement as opposed to a memorandum of agreement, setting out a legal process that substitutes for Section 106 compliance in the future for specific individual projects. And I think the concept of PAs isn't necessarily bad. That that if a project is just it's going to be too time-consuming and exhausting. Again, high-speed rail would be a good example to engage in individual consultations on every specific impact. That you do a broader public or programmatic agreement. I think that an essential component of those agreements, however, should be stipulations that the government or that the agency puts to engage the public to make sure that people know about project-specific things and doesn't use the PA to substitute their ordinary responsibilities to contact and invite interested parties. Just want to note our report. This was issued 2 years ago. The National Trust commissioned this report out of many of the concerns that I've expressed about kind of the failure of agencies to really engage the public as we believe Congress intended when it wrote NHPA. Leslie Barras is an attorney who practices in Texas, and she issued a number of recommendations to the government, to the executive department, really, just to summarize some of them, that the agencies should be inviting more members of the public to be consulting parties. You shouldn't have to know what I told you about how to write a letter and cite the applicable regulation. That's the reality, but it would be far better if, for instance, the Postal Service was doing outreach in advance of foreclosures to invite who they know would be concerned parties. I think we and CPF and others are really trying to play catch-up and hearing from local communities throughout California as to what's going on. And the Postal Service is very much aware of our interests. Consulting parties should be given a roadmap. This relates to kind of the concept of legal ease and the picture of the regulations I showed before. Not everybody should have to be able to read the regulations, so detailed, and they're pretty confusing. So giving this information out in a way that it's disseminated easily to the public is a good idea. Okay. Let's see. Changes to projects, given feedback from the process. Again, you can find this report online on the National Trust preservationnation.org. The Advisory Council has a really neat little guide, and they also have this online. It's kind of an overview in the way I suggested, not written for lawyers, but just about how 106 works, how to get involved. And now I'm going to hand this presentation over to Brian Durkin. And Brian, why don't you take it from here?
Sure. Thanks, Brian. And thanks, Jennifer, for inviting me to participate in this talk. So what I was planning on doing is just giving the perspective of the courts of how Section 106 is viewed in the courts and how judges have dealt with reviewing the process of Section 106. Oftentimes you'll see judges refer to Section 106 as like a stop, look, and listen statute, where the agency has to stop and look around for historic sites and then listen to the people or parties affected. But recently, as we saw earlier in the slides, it's much more of a collaboration of people and parties, interested parties, that should be involved in the process. And so we're hoping that maybe that's closer to the trend, is where judges will look at it much more as a collaboration than just a listening and an empty formality. So what I did is I kind of picked cases from around the country and a couple from California with a variety of issues and a variety of parties, kind of to highlight where things might have gone wrong or where the parties could have changed their actions and maybe changed the outcome a bit. So in the first case is a 2005 Boston, the City of Boston and the Federal Transit Authority planned to update a historic subway station and to make it wheelchair accessible. And it was just involving installing a couple of ramps and elevators, but that still constituted a federal undertaking under Section 106. And so what they did is the City of Boston contacted the historic property owners and the local preservation board along with the SHPO, and they found no adverse effect. But a private group, a private neighborhood group got together and said no, objected to that finding and said, no, we should have been a consulting party under Section 106. But then when the judge looked at the case, the neighborhood association made a pretty big flaw in that they didn't formally request becoming a consulting party. And so that's kind of the distinction there, is that they had to make a formal request to become a consulting party. Otherwise, they would just be treated like the general public. So that request is really important, that you get that in there. And normally it's good to do that as a letter, but definitely in writing. The next case involves a pretty large project. It was a large rail project to connect coal mines in the Wyoming Powder River Basin, and it was like a $1.5 billion project, and the environmental review went on for 4 years and involved like 1,800 public comments. And it ultimately it arrived at a pretty complex litigation that involved counties and local landowners and environmental organizations. There's a lot of complicated issues that involve this litigation, but what I really wanted to pull out again was that the local landowners wanted to become a consulting party, and so when it went to litigation, they objected and said, hey, we weren't a consulting party in the Section 106, even though we have a recognizable interest, an economic interest. But then again, the judge looked at the record and said, no, because you never actually requested to become a consulting party. And in favor of the agency, the judge saw that there was a lot of encouragement to be involved in the environmental impact statement, and pretty much everyone actually who requested to become a consulting party was granted that. So when he looked at what these local landowners were requesting, he dismissed that argument. Next is a little more closer to California. In San Francisco, some local homeowners, again, objected to a federal project that would develop low-income housing in their neighborhood. And the main issue here was the timing of the local homeowners' objections to the project, because by the time they wanted to become a consulting party, the city and the SHPO and the advisory council all had entered already into a memorandum of agreement. And by that time, it's too late to become a consulting party. So really, the local homeowners would have been better served to become involved in the process earlier. And so they made a request, but it was too late because they already had entered that memorandum of understanding. And then finally, again, in California, was the larger, a large project that some of you guys might be familiar with is the geothermal project near Medicine Lake. What happened there is that the California tribe alleged that they had violated Section 106 because there was no consultation or impact study on the historic properties. And the agency claims that, no, we don't need to do that because we've already done one, but that was back in 1988. And so when they extended the leases, they said, no, we don't need to do that, but now the tribe objected and said, no, you do need to do that. And the judge found in favor of the tribe because it was a federal undertaking and they needed to consult the tribe as Section 106 requires. So I kind of did that real fast because I know we were running out of time, but the couple of main points there that I wanted to make with these cases is that, one, the formality of it, you need to follow the formality by sending in like a letter or some, letter preferably to the agency requesting to become a consulting party, and then also getting involved early on in the process helps to become a consulting party, because otherwise you might miss your opportunity or miss that window to become a consulting party. And then finally, on the tribe definitely has a lot more rights, and agencies would be wise to consult the party or consult the tribe early on instead of trying to maybe cut corners and rely on an old EIS, an old consultation. So definitely these cases can become really complicated pretty fast, but there's definitely some key steps they can take that you can avoid some of the pitfalls.
All right, well, thank you, Brian.
Yep. Thanks, Jennifer.
Thanks both, Brian. We have actually plenty of time. So anybody in the audience has any questions for either of the Brians or both, please go ahead and type that in now, and we'll be happy to answer any of them. Do you guys, while we're waiting to see if there's any questions, do you guys have any thoughts?
Well, I would just, the poster here is for our national conference where we always have Section 106 training the Advisory Council puts on. This year it's somewhat in our region, Spokane, and on October 31st to November 3rd. So one of the issues, I'm organizing a panel on the issue of historic places and the application of NHPA in wilderness. There's a number of cases now court cases that have actually authorized the removal of historic structures in wilderness, and it kind of leaves open a question as to what the how NHPA is to work in congressionally designated wilderness areas. So, looking forward to that.
Any questions? There we go. So the question is, what is your obligation as a federal agency to invite local groups to participate as consulting parties in the Section 106 process versus notifying local groups of the project?
Well, if the federal agency has determined that, indeed they have an obligation here, that there's potentially, affected properties in the area, I think that the obligation to notify is really the same as the obligation to invite, in a way. I mean, if we're speaking purely in principle here as to what NHPA was intended to do, it's if you notify a notification to a group is going to come pursuant to some legal obligation generally. So NHPA, has specific notice requirements that might be different from NHPA, for example, and it's important for the federal agency officials when they're kind of looking at all the different laws that could be triggered to say, okay, well, we have NHPA responsibilities. We also have Section 106. I would say that best practice for an agency would be to make sure that their notice states their intention to follow whatever federal laws are triggered and invite those parties to be a part of the process. I think what happens most commonly in the field is if it's a big project, if the agency knows that there's possibly some opposition or interest, they'll hold a public hearing. They'll invite people to come, look at some of the project maps, and they'll have a discussion. Now, I always, if I go to those meetings, I generally don't see them talking about 106 and the right for parties to be involved. I mean, we would say it's a legal obligation, but quite honestly, the way it works in reality is that it just doesn't always happen. Now, if you could take them to task by seeking a legal remedy, but I think that the court would say that you need to first exhaust your administrative remedy, which is to raise the issue with the SHPO or the advisory council first. So it's a great question, and it's definitely an ongoing dialogue, and we're trying to push the agency to do as much as to send as complete information as possible about the 106 process when they initiate projects really early in project planning.
Are there any additional questions from the audience?
Meg, I'd love to know if that helps answer your question or if you have any, whether I hit it on or not.
Okay, we'll see if there's an additional question. In the meantime, thank you again for joining us today. Later today, you'll receive an email with the link to the survey. We would appreciate any feedback on this webinar as well as recommendations for future topics. We'll be getting ready to set the calendar for the next year. If you would like a copy of today's webinar, I will send that later today. I sent out the notes, but I will send an actual, a larger version. Our next module in the webinar series, or not this webinar series, but our new webinar series will be on the California Historic Building Code, and that will begin on August 14th. We did have one additional question. The question is, when a consulting tribe is not notified during construction of a find, what is the recourse?
Great question, Patty. a PA is in place, that's the first question, I guess, is, that basically at the end of consultation prior to construction starting, that agreement has to be in place. It could be a PA or MOA. And once you're in that world, that Section 106 compliance has been achieved prior, that the Historic Properties Treatment Plan is in place. And the PA basically presumably authorized the production of the HPTP prior to construction starting. So once you're in that universe, you're dealing with the provisions of the PA, because that's the legal agreement that sort of sets out that it's there to sort of set out the process. So the agency, presumably, when there's a conflict, the agency has done something but hasn't done enough in the tribe's view. So the PA would specify, dispute resolution procedures, and generally that involves like a formal notice to the advisory council and a request, or the SHPO, or both, and a request for that dispute to be sort of litigated between those agencies. When that's not enough, there are other provisions in the PA that permit termination. One party might decide that they don't want to pull out. And then, if a group, whether it's a tribe or even a concurring party, is unsatisfied with the way the process went, or doesn't feel like the terms of the contract were kind of executed in a good faith manner, then I think that there is a potential to have legal redress in a court for failure to abide by contractual provisions, because fundamentally NHPA is there to protect the public interest. So reminding judges of that is always a good thing. So if an agency if there's, that would be another thing to bring up. I mean, if you feel, again, what a court is going to want to see is, this idea of exhaustion of administrative remedies. And administrative remedies are basically everything that you can try to do under the terms of that 106 agreement. And, there's a point to which you feel like, it's a consistent pattern of not engaging in kind of a good faith way with the tribe, then I think you've really established that you've done all you can within that procedure, and you need to seek legal recourse in a federal court.
All right. Well, thank you very much for your questions, and the Bryans for their presentations today. And like I said, you'll receive a survey later today, and I hope you guys all have a good rest of the afternoon, and thank you for joining us today.